Well, hello everyone, and thank you for being here. You've landed on the live stream session, your employment law live stream session specifically with me. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're here to find out about your legal rights when it comes to employment law and workplace and your job and your boss and your compensation. This is your opportunity to ask questions of me. Again, I'm Lior Samfiru, the employment lawyer. By the way, my firm, Samfiru Tumarkin LLP, you will find us across Ontario, BC, and Alberta. So we've got your back here. We want to make sure that you understand your rights and, of course, to help you enforce those rights. Understanding the rights is key. That's step one. Step two, of course, always enforcing those rights. So what can we do here for you on this live stream session? Well, live, right? I'm here for you. You can ask your question. If you're having a bad day and your boss just gave you an ultimatum saying, well, after the holidays, your job is going to change, your compensation is going to change, maybe your work location, ask the question. Tell me what's going on. I'll tell you what it means and what you can do, and if it's legal or not legal. If you've lost your job and you're concerned about what that means and what you're owed, such an important topic. So many people over the past year have lost their jobs, unfortunately. We can help you. We literally help thousands of people every year in those situations. If you're worried about losing your job, if you're being mistreated or bullied, if you're not getting paid what you're owed, I think you get it. If you have a legal issue about your workplace, an employment issue, this is the time and place to ask the questions to get some answers and help. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And on this session, you got me live. So before we start, I want to also give you some other contact information. It's so important to have that at your fingertips. If you want to reach me and my team when we're not here on live stream, so easy to do. All you do is you go to employmentlawyer.ca. Address is right over there. Employmentlawyer.ca. Couldn't be easier. And all the contact information you can ever need is right there. You can send an email, you can make a phone call, you can send a message, and we'll call you back. It's easy, couldn't be easier, actually. Again, employmentlawyer.ca. But right now, I am live. I'm going to start answering questions, but I want your question. You have time today, okay? Make sure that as we go into the holiday, you know what your legal rights are. You're not stressing out over the holidays about your job and what your boss is doing. Ask the question of me right now, and I'll tell you what you need to know. All right. I think it's time we start answering some questions. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live answering questions. And our first question of the day from Facebook, and this is from Brianna. What happens if your employer demotes you because they can't afford your role anymore, but they keep hiring new people for other positions? So here's the thing. And my answer is going to be the same whether they're hiring or not hiring, whether they're legitimately can't afford you or they're lying about it. The reality is, in most cases, your employer is not allowed to demote you. Simple as that. Good reason, bad reason, no reason. They're not allowed to do that. What does that mean? The fact that they're not allowed does not mean that we can get the police to come in and stop them from doing that. We can't physically restrain them from doing that. But what it means is, if your employer demotes you, that may be what we call a constructive dismissal. What that would do then is it would give you the right to say, wait a second, not allowed to do this, employer. I'm going to treat this as a termination of my employment. Now you have to pay me my full severance. I'm going to leave, but the law is going to look at it as if the employer has terminated employment, and then the employer has to pay severance. Listen, a demotion could be obviously problematic. It can hurt your career. It can even be embarrassing. And the law in most cases would say, no, you can't do that. That's not a term of employment. So if your employer demotes you, you can accept it and continue working, of course. Or you can say, wait a second, constructive dismissal, not cool, not good at all. Let me leave now and I'm going to get my full severance. Of course, if that's what you want to do, if you want to go the constructive dismissal route, before you do anything, before you walk out of the job, before you tell your employer that you're gone, I want you to call me. We need to dot our I's and cross our T's. We need to have that discussion. Of course, that contact information right over here, again, employmentlawyer.ca to have that conversation. So a lot of people think, well, they demoted me, but they're lying about the reasons. They think that that is the problem. The problem is not the lying about the reasons. The problem is the demotion itself, not allowed in most cases, right? So if you've been demoted, if you're getting a different job that's not the job you signed up for, that could be a constructive dismissal. Thank you for that question, Brianna. You see how easy it is. I'm going to continue answering questions, but in the meantime, you can ask yours as well. And if you're just joining us for the first time, thank you for being here. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live with you at your service, answering your employment law questions. So, by the way, I see questions have come in. I'm going to get to every single one of them. Next question is from Lichi. I'm trying to understand how to interpret the resignation clause in my contract, which requires 3 weeks of written working notice and allows the company to waive the notice while still paying me. If I resign on December 12th, the 3-week period ends January 2nd, which overlaps entirely with the scheduled office shutdown. I'm trying to find out whether the shutdown still counts towards my notice period and whether my employer could argue that those non-working days don't count and push my end date beyond January 2nd. No, they can't. So those dates would count towards your notice that you have to give them. So it's absolutely fine to provide that. The fact your employer is choosing to shut down, that's its decision. So yeah, there's no issue with that. You can provide that notice. They really can't do anything. And in most cases, it's very difficult anyway for an employer to enforce a certain period of notice. So not something you need to stress out over. Thank you for that, Lichi. Great question. Happy you've asked it. I'm going to continue answering questions. But guys, I want even more questions. I want to be on my toes for the rest of the session. I want to be exhausted by the time I turn off my webcam here because I've answered so many questions. So ask them. Don't be afraid. There's no such thing as a bad question. I've never received a bad question in 22 years of answering questions. So do the right thing and let's make sure we get some answers to you. All right, the next question today comes from Brian. My partner just got let go from a job in tech. Jobs are scarce lately in the industry. Does this change what his severance should be? If he was offered 3 months as a 6-year employee, is that enough? So absolutely not enough, not even close. And by the way, the market conditions absolutely impact severance. If you're let go in a job or a profession or industry where it's going to take you longer to find another job because it's a bad market or there's no job, that will increase your severance, absolutely increase your severance. Now, the main factors that would go into assessing are your age, your position, and the length of your employment. So all I know is that your partner has been there for 6 years. I don't know his age or his position, but I can tell you that there's no world where that's going to be less than 6 months severance. And it could easily be as much as 12 months severance. So if he was offered 3, at a minimum, that's half. That's 50% of what he's owed. But it's probably a lot more. But he's probably owed a lot more than that. So the offer is that much worse. So Brian, yes, you've made the right decision by reaching out and asking the question. Clearly your partner is owed more. But there's the next step that your partner needs to take, and that is to reach out to me so we can have a discussion, go over the details, and I can make sure that he gets what he's owed. If it's going to take him a long time to find another job, it's that much more important to get his full severance because he needs that severance to carry him until he finds a job. If he finds a job tomorrow, he may not care so much. What if it takes him a year to find another job and he accepts 3 months severance? Terrible. So Brian, have him call me, okay? To connect with me, you see the contact information on the screen below, employmentlawyer.ca. All the contact information is right there. Please have him do that. I'll be happy to connect with him, help him make sure that he gets what he's owed. Thank you for that. Great question. See how easy it is, right? Very important situation. Person gets let go, and just like 90% of people, when he was let go, he was offered a lot less severance of what he's owed. So some people think it's a month per year, a week per year, 2 weeks per year. All of that is wrong, okay? It's wrong, wrong, wrong. So how do you find out how much you're actually owed? If you want to understand your real severance entitlements, here's how you do that. You can do that, and Brian, your partner, can do that right now. All you have to do is you go to pocketemploymentlawyer.ca. You see that address over here, pocketemploymentlawyer.ca, and you click on the severance calculator. That's it. It's as simple as that. Once you're there, you answer a few questions. Takes you 10 seconds. and you're going to find out how much severance you are owed, the real amount, what the law provides for you. Okay, it's not a week per year, it's not 2 weeks per year. For the majority of people, it's a heck of a lot more than that, even if you only work for a few months. It's completely free, completely anonymous. Well over 2 million Canadians have used it already. Check it out. Again, pocketemploymentlawyer.ca. Use that severance calculator. We've built it and created it for you so that you have access to knowledge about your severance. Thank you, and check that out. But now I'm still live. A bunch of questions have just come in. Please keep them coming. I'm not afraid of them. I want them all. Ask the questions. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm going to continue answering more questions. D'Angelo has our next question. My mother's employer has been telling her she should retire, and we're worried they're trying to force her out. What sort of protection does she have? Is it discrimination if they let her go for age? Yes, it is absolutely age discrimination if someone is let go because of their age. Even if age is one of several reasons why someone is let go, it's illegal. Age should be no consideration whatsoever in deciding to let someone go. We used to have mandatory retirement in Canada. We got rid of that about 20 years ago or so now. So your mother, anyone, can work till 65, 75, whatever age they want, and no one can do anything about it. So if they are telling her she should retire, she should simply say, not interested. I will let you know if I change my mind. Please don't talk to me about it anymore. And once she does that, they're not even allowed to talk to her about it anymore. Okay? If they do anything to her and you suspect it's because of age, have her call me right away. By the way, even if they let her go for unrelated reasons, maybe they shut down the whole department, so it's nothing to do with age, she has to call me even then, because she's going to be owed significant severance. Remember, age is one of the factors that goes into assessing how much severance someone is owed. So if your mother is older, she's going to get a lot of severance. So hopefully that helps D'Angelo. She cannot be let go. No one can be let go because of their age. It does happen, which is completely and totally and utterly illegal. All right. So, but now you know what to do, or she knows what to do. She needs me. Easy. Contact me. employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic questions, guys. You guys are the best. Let's keep them coming. I'm Lior Samfiru, the employment lawyer. We'll answer more of your questions right now. Lisa is joining us from Facebook. I was given a return to work date after being on long-term disability, but my physician recommended some accommodations to return. My employer is refusing to approve or even acknowledge my request, and my return to work date is next Monday. Seeing how he's not communicating with me in good faith, can I consider his silence as breach of his duty to accommodate and consider this as a constructive dismissal? So what I want there to be some sort of a record in writing. So it can't be verbal. In writing, where you've sent them your doctor's note that outlines what your accommodation needs are. So I want you to send that to him. He doesn't have to necessarily respond to you. What he does have to do is, when you're coming back to work on Monday, that accommodation has to be in place. I'm not as concerned if he doesn't tell you in advance, hey, we have it all ready for you. It does need to be ready. So once you go in Monday, if somehow they've made accommodations and they're okay to accommodate you, no problem. Everything is good. You continue working. But if you show up and they say, no, we're not going to accommodate, just do your old job. At that point, you leave, you send them an email saying, here's what happened today. Okay? I showed up to work, you didn't accommodate, you refused, I provide you my doctor's note, and then you call me. That is absolutely a constructive dismissal. That could be a human rights violation. It's illegal. But I don't want you to say that before you come in, because all we know right now is they haven't responded to you. I want you to go in, and if there's no accommodation, call me, okay? Please do call me. I can do one of two things for you. I can either force them to accommodate you if that's what you want, or I can get you out of there with compensation. Either way, you're going to be in control. So make sure it's all in writing, and make sure you send them a note after Monday if they didn't accommodate you, and call me right away. Don't wait on that. employmentlawyer.ca, Lisa, to do that. I'll be happy to connect with you. Obviously, it's a difficult situation. I'm sorry you're in that situation. We can easily fix it, okay? employmentlawyer.ca to connect with me and my team. So make it happen. By the way, Lisa, if you have a follow-up question, I'm still here. You still have time, as do you as well. If you have a question and you haven't asked it yet, please ask it. You have time. If you ask your question right now, I promise you an answer by the end of this session. More questions have come in, so I love that. I'm going to continue answering them. And of course, if you're just turning on your computer now and joining this session for the first time, glad you're here. You've joined me, Lior Samfiru, the employment lawyer, and I'm answering questions live about employment law and workplace rights. Our next question is from, let's see, Carlos. How long after initial consultation I have to present your firm documents? I'm not sure what you mean by that. In the consultation, we will discuss everything that needs to happen. So when we do the consultation, we will discuss everything that's going to happen. When is it going to happen? Who's going to do what? So we're going to do that all at the consultation. So if you have a legal issue, an employment issue, just reach out to us. Let's schedule a consultation. Let's do this right. We can answer all your questions and have a strategy in place to resolve your workplace issue. So Carlos or anyone, again, to connect with me and my team to have that consultation, easy. Just go to employmentlawyer.ca. All the contact information you can ever need is right there. All right, let's see. Next question is from Lisa, another Lisa. Can my employer deny my request for accommodation due to family status, only saying that I do not qualify, not answering my question of what does qualify? So it's not up to your employer, Lisa, to decide if you qualify. They don't get to sit there and make that determination. Now, not every situation qualifies. I'll give you an example. If you have a cousin and that cousin wants you to pick up their kid from school because they're busy, that's not family status. On the other hand, if you have a child, give you an example, that requires you to pick them up from school and there's no other arrangements that are available to you, your employer must accommodate you so you can leave on time to pick them up, or maybe to change your shift instead of nights to be days. So if it pertains to your child or to your parents, then yes, if the only way to meet the obligations is by your employer accommodating you, they have to accommodate you. It's not optional. They don't get to sit and decide. So it has to be tied to your parents or your children. And really the simple question is this: in order to meet your obligations to them, is really the only way to do that, is it with the employer's accommodation? If you can't do it without the accommodation, they have to accommodate. So if they're not cooperating, Lisa, you know what to do, hopefully by now. Reach out to me. I'll take care of it. Okay. Once they hear from me, see how quickly all of a sudden, yes, of course we'll accommodate. It was just a big misunderstanding. So to connect with me, Lisa, very easy, employmentlawyer.ca. Let's have that conversation. And of course, I'm still here, by the way. If you want to ask a follow-up question, why not? Ask it. You have time. You as well. If you're joining me now, Lior Samfiru, the employment lawyer. And if you haven't asked your question, don't wait much longer, okay? We're getting to that point where you really want to ask that question to make sure you get an answer from me today, okay? All right, let's continue answering questions. I love this. Next question is from Brash Ash 543. After I announced at work that I was expecting, my manager has suddenly started to find problems with my work. All of my reviews up to now have been glowing. I think they're trying to get rid of me. Before I go off, to get rid of me before I go off on maternity leave. I'm very nervous about this. What should I do? Okay, so as you probably expect, it would be completely illegal to let you go because you're taking a leave. And I've seen this before. Employee is doing well, there's no issues. All of a sudden, they become a bad employee somehow once they announce that they're pregnant. But it's clear what's happening here. So what I want you to do is I want you to send an email to your employer expressing these concerns, just like you've done with me now. Send an email, very respectful email saying, here's my concerns. I've always been a good employee. I've always got good performance reviews. All of a sudden, once I announce that I'm pregnant and I'm going to take a leave, all these issues have happened. I'm concerned that I'm being targeted. I hope that's not the case, but I wanted to point that out. If you do that, they're going to be insane to then turn and let you go. Okay, I want that to be on record that you sent that email. If they do anything to you at that point, you call me, and man, is the law going to take this very seriously and punish them. Letting you go could be a violation of a few statutes. It's completely and totally and utterly illegal. If they're that dumb to do it, man, the law's not going to have any sympathy for them. But I want you to send that email. Okay, send that email. It's okay to send it. You don't have to be mean about it. You don't have to be, aggressive. Just very factual, and doesn't even have to be long. But I want that there. It protects you, and it makes it so that if they do anything to you, there's going to be consequences. And of course, to connect with me with any issues, any problem, very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca. So Brash Ash, if you need me, you know how to reach me. But in the meantime, do exactly as I've said. All right, fantastic questions, guys. You guys are the best. More questions have come in. I'm going to answer them right now. So please ask yours too if you haven't yet. Man, let's make sure you get those questions under the wire. Let's see. Dreamland879 has our next question. I'm a returning seasonal employee. Why would a company want me to sign a new contract every season when there are no real changes to pay and the job description is the same? Why? Because they're not getting proper legal advice. They think that there's a reason for that. There isn't a reason. It doesn't do anything. So the only reason they're asking you to do that is because someone told them that they should. Makes no sense. It doesn't do anything. It doesn't change your legal entitlements. So it's something your employer does because they think that's the right thing. It's not necessary. You can sign one agreement saying you're a seasonal employee, and that's that. So yeah, don't stress out over it. It's just your employer doing it because someone told them they should. By the way, if you're just joining us for the last 7 or 8 minutes of the session, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live with you answering your employment law questions. I'm going to continue answering questions. Next question is from TI1U. My brother is special needs on the autism spectrum and developmentally stunted, and my mom is getting old, and I'm taking the responsibility of his caregiver. Would this count as a need for family accommodation, or no, because he's my sibling and not my child parent? It would not, unfortunately, count in this situation. But if it was taking care of your parent, that'd be different. Maybe your mother needs support because of her age. That support could have something to do with your brother. But if you tie it to your mother, that my mother needs me to support her in this way, there's no one else to do it, that now becomes a family accommodation requirement. Okay, so hopefully that makes sense. And so tie it to your mother, and you may even be able to get a doctor's note from your mother's doctor saying that there's these needs that your mother has, and you're the only one that can support her. Hopefully that makes sense. TI1U. Questions, comments, concerns, problems, you can reach me through employmentlawyer.ca. All right, let's see. Next question. Nightingale Z3D. Nightingale. Can an employer change your compensation or commission structure at the end of the year right before it is due to be paid out? It'll be a 30% reduction in what I make. Absolutely, positively not. They cannot do that. So first of all, they can't change things retroactively ever. What I mean by that is if you have a deal that says you'll get this amount of money based on these commissions, they can't say, well, we've decided to change it, so now you're not going to get that money. No, that's not legal. They'll still have to pay you the money, and it doesn't work that way at all. But what happens if they're not doing it retroactively? They're just changing it going forward. So for 2026, we're going to change your structure, and now you're going to make 30% less in 2026 because of this change. Well, that could easily be a constructive dismissal. Essentially, what your employer is doing is giving you a 30% pay cut. Can't do that. Constructive dismissal. So while you can't physically stop them, what you may be able to do is consider that a termination and get your full severance. Okay? So, and that's probably better than accepting the change. Here's the problem if you accept this 30% reduction. If you accept it and continue working, then you're potentially giving them the right to do it again and again in the future. So next year, if they reduce it again by 30%, you won't be able to do anything because you accepted it back this year. So you have to be very mindful of that, Nightingale. But of course, if they want to avoid paying money that you've earned for this year, can't do that. If they do anything, you reach out to me, okay? employmentlawyer.ca. Again, employmentlawyer.ca. I'll help you. And let's make sure we do this right. Contact information is on the screen. I'd love to talk to you and help you. All right, I see a few questions. I want to get to all of them, so I'm going to continue right now. Again, I'm Lior Samfiru, the employment lawyer. Robotic person. Is it appropriate to punish an employee for not hitting office attendance if the reason was a disability they had not yet reported? Well, if your employer doesn't know that you have a medical condition and you're not showing up to work on time, then they're going to discipline you, right? Because from their perspective, you decided not to show up to work. So you have to tell them about it and even give them a doctor's note saying the reason you couldn't come in is because you had this medical issue, okay? And if you do that, then no, you can't be disciplined. But your employer obviously can't read your mind. So if they don't know there's a medical condition that's affecting your attendance, they'll discipline you, right? So keep that in mind. But you can still get that doctor's note and let them know what's happening. It's always a good idea if your performance, if your attendance is going to be affected for medical reasons, it's a good idea to let your employer know in advance so that you won't be punished, so that they know and that they can accommodate you, which is, of course, their legal obligation to do. Okay, let's see. Next question is for Margaret Roberts. Are there different rules regarding severance for municipal employees? Non-unionized, less than 2.5 million payroll and less than 50 employees. So first of all, the size of the payroll and the number of employees does not matter. Zero consequence to your full severance entitlements. Does not matter. Whether you work for a company with 1 employee or 1,000 employees, you're still going to get your full severance. So no, for municipal employees, for provincial employees working for the government, if you're not unionized, you're going to get severance regardless of the size of the payroll. Again, the size of the payroll doesn't matter. The factors are your age, your position, and the length of your employment. And Margaret, if you want to find out right now how much severance you're owed, you can do that in seconds. Grab your smartphone, your tablet, your desktop, and open up your browser and go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca, and you'll get your answer there. Click on the severance calculator and find out exactly what you are owed, okay? So I'm glad you asked that question. A lot of people think that, no, I only get severance if I have a company that has a certain size of payroll, a number of employees. Does not matter, okay? Does not matter. So that's the key. Please be smart about that and always make sure you do that. Too many people accept bad offers because they don't realize that they're owed severance. Don't let that happen to you. All right, let's see. I think a robotic person has a follow-up. Can an employer punish you for the timing of disability disclosure? I disclosed real disability with medical notes, but only once discipline started and being called out for that. No, they can't. As I said, of course they can't. It's not a good idea to wait because your employer does or should know what's going on with you, but they can't be disciplined because you told them after the fact. You do have ability to make that decision, so there shouldn't be an issue with that. All right, I told you I wanted to be kept busy by you guys, and you did it. Thank you. I appreciate that. Fantastic questions we've had on this session today. We've come to the end. I think I've answered all your questions, but if you have more questions, or if for some reason I didn't get to answer your questions, no problem. I'm not going anywhere. You can still reach me and my team across Ontario, BC, and Alberta. All you have to do is you go to employmentlawyer.ca, right there, employmentlawyer.ca. All the contact information you can ever need is right there. So now that we're at the end of the session, I'm going to say thank you again to you. I'm Lior Samfiru, the employment lawyer. Always a privilege to be here to answer your questions. Let's continue the discussion privately if you need to. Otherwise, I'll see you all again very soon. Take care of yourselves and be well. Bye now.